All right, good afternoon, everyone, and welcome to today's Lunch and Learn. We are thrilled to have you here for what promises to be a valuable discussion. Our speaker today is Bill Barrett, a seasoned patent attorney and partner at Wilson, Tononi, and Goodrich and Rosati. Was that close?
Pretty close, yeah.
Pretty close, okay. With over 2 decades of experience, Bill specializes in intellectual property strategy, helping deep tech and life sciences companies protect their innovations and maintain a competitive edge. Beyond advising startups, Bill has firsthand experience as an entrepreneur himself, having been a part of 3 startups. This unique perspective allows him to guide founders through the complexities of IP law with both legal expertise and practical insight. Today, he'll be sharing key strategies for navigating intellectual property in the fast-paced world of technology and innovation. Please join me in welcoming Bill Barrett.
Thanks. So I have one set of slides on here and one set up here, and when I hit this, that doesn't move. So last time I did this, I kept hitting this and forgetting to hit that one until somebody in the audience volunteered to help me out. So would somebody be willing to help me out and move those slides when I move these slides?
Here we go, Bill.
All right, thanks. I'll try to keep an eye on it, make sure I'm on the right slide. Yeah, so intellectual property licensing. So how many people in here, have been involved in intellectual property licensing? A couple. Would you guys like to sort of explain sort of your experience, like what kind of license you were involved in and why?
With my coworker here, we work for the tech transfer at TSU.
Oh, okay, great, yeah.
So it's, helping startup companies or IP develop at TSU by faculty and researchers.
Okay.
To be commercialized.
Awesome. Well, hopefully you guys will speak up a lot and give that university perspective as I'm talking here. How about you guys in the back?
I've had experience licensing from university.
Okay, yeah.
It's really interesting how different they can be.
Absolutely, yeah.
I would say how incompetent some licensing in university are.
Yeah. Yeah, that's right. And different terms and different processes, it can be challenging at some universities and very easy at other universities. Anybody else?
I worked in a small company, and we had to capture some of the technology that we utilize internally, and we were beginning to sell them into other products to try and prevent competitors from ripping off our, leading technology.
Okay.
And did that on various projects for a very smaller company.
Okay, so maybe you were granting licenses to other companies, or?
Actually, they weren't licensed.
They weren't, okay, just selling it, yeah.
Just for us, yeah.
Gotcha. Okay, cool. I thought I'd start by talking a little bit about a company I was involved in for 8 years. If you guys have ever heard me before, you might have heard me talk about this company a little bit. It's the company in the middle called Advanced Liquid Logic. And when we had this cool digital microfluidics technology, which I won't get into, but it's basically technology that moves droplets around on a chip and allows you to do chemistry. So it's a kind of a laboratory on a chip. It did lots of different things. So when we started, we had this license. These red arrows are licenses, right? So we had a license from Duke to the technology. And then pretty soon we realized, there's some other companies out there that have maybe some earlier patents that are pretty, covering what we do, or some related patents, and other entities. So this little company, Nanalytics, was a small company that was trying to get off the ground. And then the CEA up there was the French Atomic Energy Commission. They had a bunch of patents, believe it or not, in the space. And this little company over here, Core Micro Solutions, was a spin out from UCLA. So we were like, okay, we've got this great technology, we're working to develop it, but there's all this other IP that we're worried about. And if we go to sell this company, they're going to find all that IP, and it's going to be a problem for us. So we went out and we were able to, as a small company, we bought Nanalytics with some stock, basically, because they were floundering. We went over to France and licensed the CEA IP. And then we bought Core Micro Solutions, which was also struggling to raise money, and so we were able to do a stock transaction and a little bit of cash and buy them. So we were able to gather all that IP that we were worried about together in one place. And then on the other side, we built this sort of huge IP portfolio, and then we were We were funding ourselves with grants, but mostly, we had a little bit of seed money. So we needed money, so we started, monetizing the IP. So we went to this company called NewGen, which had, was developing some tests and needed some technology, and we licensed it to them. We went to Luminex, and they had, specialized beads for doing bioassays, and they wanted some technology to do their assays on, so we licensed it to them. And then that company up in the corner, Genmark, they were doing sample preparation for DNA sequencing technology, more chemistry. We could do that on our chip, so we licensed it to them. And then so we made some money out of each of those, and that helped the company keep going. And then we sold the company to Illumina for $100 million. And the two founders who had just basically, they graduated with their PhDs, started a company. They walked away with millions of dollars in their pocket, which was pretty awesome. And then the founders of Liquid Logic licensed the technology again back from Illumina to do another company called Babies, which was using the technology in a specialized area for screening newborn babies for various kinds of genetic issues. And then this company, NewGen, wound up being sold to Roche for $1.2 billion. But you can see, licensing is a big topic. This is one little company, Liquid Logic, and all these licenses were surrounding it, both to bring technology in, to send technology out, to sell the company, and to even license it back and develop a new company and basically sell the same technology over again to somebody else. Babies recently did a sub-license as well, and eventually they'll have an exit that's based on all the same technology. So licensing can be a very powerful tool for monetizing technology. This is a bundle of sticks. Anybody have any idea what a bundle of sticks has to do with licensing? You guys know.
There together, it's very hard to break.
Yeah. So this is it's an old thing in law that you describe property rights as a bundle of sticks. So next slide is, so property rights we think of as a bundle of sticks. So like if it's real estate, you have maybe the right to build something on it or the right to keep people off of it or whatever. All those rights are a bundle of sticks. And because they're separable, you can give different parts of it away. So intellectual property rights are also like bundles of sticks. So with a patent, you have the right to make things, to use things, to sell things, to offer to sell things, all these different rights. You have rights in different geographies, or you can slice up your rights like we did at Liquid Logic by different fields of use, right? So those are all those different sticks. And what licensing is, it's a way to give away some of those sticks without giving away the whole bundle and the basic rights. So, if you're Liquid Logic and you give, say, Luminex was the company with the special beads, you say, I'm going to let you use my technology only with your special beads, and that'll be your thing, right? And so I can give away that stick and get some money for it. So that's basically how we think about licensing. Licenses have a weird thing in law is that if you give away too much, it'll be considered an actual sale of the technology, which you want to avoid. So you're always trying to keep back, what you're not giving away. By the way, this would be great if you guys ask questions as I go, and make it a discussion instead of just me giving a lecture here. So some preliminary considerations. Awesome. So before you even get into a license, it's helpful to think about why do you want a license? What's the whole point? What are some reasons that you guys can think of for licensing?
Bringing some revenue.
Right, that's good. One. You guys have.
Oh, for us?
Yeah, for you guys.
We're licensing because we are not like manufacturer of any, or service provider and selling to end consumers, either
Right.
businesses or businesses.
It's a way to get your technology out to the world and get it into a real product that actually goes out and benefits people as opposed to being an experimental thing in a lab, right?
And it's a way to create a new industry.
Yeah. It could be a way to bring in technology to improve your own products and processes. Sometimes it's a way to get freedom to operate, like we did at Liquid Logic. We saw these other patents that we were potentially infringing, and so we brought that in, so we wouldn't infringe those patents. So those are just a few things, a few reasons. Another reason is just to get a trading chip. So when I was at a company called Grail in the Bay Area, we kind of got into the space late of liquid biopsy, where you're testing blood for DNA to screen for cancer. And we realized early on there's this one particular technique called molecular barcoding that we needed, and that other people, our competitors, had the IP to it. But then we went out and looked around, and we found this other IP that it was just sitting out there in the same space. It was earlier than our competitors, and we were able to go do 2 different licensing deals and be able to sort of scoop our competitors who had started earlier than us, but now we had IP that was earlier than theirs, using a license. So, yeah, sure.
Quick question, how long does IP last as far as being protected if you aren't doing anything active to protect that, say, patent?
Yeah, so patents last for 20 years from the filing date. And it doesn't matter if you're doing anything active or not. They could just sit there for 15 years, and then maybe the last 5 years, you're actually able to do something with it, and it's got some value. So, and a lot of times patent lawsuits are filed at the very end of the patent term. You know, maybe you got 1 or 2 years left, and you're filing a patent lawsuit, because the technology has over 20 years, become really valuable.
Could you just touch on the speed to market thing?
Yeah, well, I mean, yeah, that's a good question. So think about the difference between, say, bringing in some technology that's already well developed that you can implement in your product right now versus having your R&D group work for a few years to kind of develop it, right? So, in licensing technology and IP is a good way to sort of speed your way to market, yeah, in some cases. So this is about evaluating whether licensing is necessary. Like, okay, so you're gonna have to pay something when you license. Maybe the university has some great IP, you like it, you wanna develop it, but you wanna take a close look at it, say, do I really need it? Maybe you could quickly find a way around it, right? So you don't need it, so you don't need a license, you don't wanna pay that license. So thinking through, why do you need it? Do I really need it? And making sure you make a good decision there before you license it. It's pretty common, I think, for our clients who are often spinning out of universities to think that the university IP is one thing when it's really something else. So you have to take a close look at it and see, what does it really cover? Like, not just the technology area that it's in, or not just the cool thing that you read in the paper that the researcher produced, but actually what those patent claims say at the end of the patent, and how broad are they, or are they actually covering something that would be a product for you or a service. So the next part of the licensing process is assessing the IP to be licensed, right? So let's say you find some IP that you want to license, some patents, and the first thing you want to know is, are they valid, right? Because they might just be, obvious, they might be invalid, they might be not enforceable. So do you really want to license IP that's not enforceable? Maybe you do, but most likely you don't, right? And then thinking about other IP that's around it. So in the university perspective, you oftentimes that researchers, maybe they filed some other IP in the past that's related to the IP that you're looking at. Maybe it encompasses it and blocks it. Or maybe there's other related IP that they're working on now that hasn't been filed yet, or will be filed soon, that you'd like to get your hands on. So just looking at the whole scope of the IP that's there to license, and make sure you don't license one piece, and then 2 years later you have to go back and go, oh, wow, I need that other piece, I should have gotten that. So make sure that you're getting everything that you need. And then the other thing to think about is freedom to operate. So let's say you want to do a license, you want to make a product that's within the scope of the patents that you're licensing. If you do that, are you going to infringe anybody else's IP? That's what we ran into at Liquid Logic. We realized that we had this great IP from Duke, but we needed other IP to make it work. So making sure that you look at that as well. And that can help you to think about what the value of the IP you're licensing is. So if the university is coming to you and saying, we want X% royalty, whatever, if you go back to them and say, this is awesome IP, we really love it, but we're gonna have to also get this other IP. Is there a way we can kind of like make sure that we're not gonna have to pay too large of a royalty for the whole bucket of IP? And there's different ways to do that.
How do you become aware of all the IPs out there? There must be like databases we can go browse,
Yeah,
or
yeah.
other, right?
Yeah, I mean, one good source is just Google Patents. There's a Google site that's just for patents, and you can search out there, and that's you know, it really often brings you right to the most important stuff, just like Google. But then there are all kinds of, well, like patent attorneys use all kinds of different databases, to do searches and monitor for other IP and that kind of thing.
How did you do it for your company when you were involved with the one in yellow?
The Liquid Logic?
Yeah, for the French people and this other IP that you identified it was required for your.
Yeah, so I was doing searching, you know, with a patent searching
Database?
tool, yeah, and keeping kind of a big list of all the IP in the space. And, yeah, we identified it that way. Another thing to think about before going into a license agreement is kind of take yourself all the way to the end, okay? What happens if this doesn't work out, right? What happens if we fail? Because you want to go into a licensing discussion, making sure that you get licensing terms that you can really live up to. You don't want to breach the terms easily, right? So thinking about what happens if you fail. So what is a breach? A breach of a contract, which is a license is a contract, right? Is a failure to comply with the material obligations in the license agreement. So some common breaches include things like non-payment of royalties or milestone fees. So it's pretty common to say, okay, we're gonna license this from the university, and we're gonna have some milestone fees that are payable. They could be payable triggered on different things, like it might be payable like when you file for approval with the FDA, or it might be payable at a certain date, right? And you wanna make sure that when you're planning well, so that when you look out in like 2 years from now, you've got a $50,000, you know, milestone payment, that you're actually gonna be able to make that, and you're not gonna breach your agreement by not making that payment, because then you have to go back to the university and say, sorry, we breached, you know, and try to fix it, right? You don't wanna be in that situation. Sometimes you can't fix it. Sometimes in the meantime, a big company's been knocking on their door saying, hey, we really like that IP that you out-licensed. If it comes back to you, we'll out-license it from you, right? So they may say, oh, sorry, you breached, we're gonna give it to somebody else, right? And then you'll have to put in all that time and effort into developing it, only to lose the rights, right? But why does breach matter? Because when your rights are terminated, then the licensor can revoke the license, and then you don't have the rights anymore. Now you're infringing, right? Because you're working in that technology. So there's this risk that you could get sued for patent infringement by the university or by a subsequent licensee. There can also be financial penalties. Another impact could be what happens to sub-licensees. So a lot of times you will license IP from a licensor, and part of your plan is like we did to sub-license it to other people, like we sub-licensed it to Luminex. Now, Luminex really cares a lot about our license, because what happens if we breach our license and we lose it? Because their rights are flowing through our license. And licenses will often have terms to deal with those kinds of things, to make sure that Luminex is protected if we screw up. Because Luminex could be paying us all their royalties, right? And we're supposed to be paying 50% of that to the university, but we're tight on cash, so, you know, we're stretching it out, and we haven't paid, so we breach, and then suddenly Luminex is unprotected. So thinking about breach in that perspective as well. So now I'm gonna move to some key license terms and some pitfalls. License agreements are really complicated, as you can imagine. There are tons of important terms in there. I just picked a few things here to talk to you guys about today. There are lots of other concepts that I could talk about, so if you have any that I'm not bringing up and you want to talk about, feel free to bring those up. Before I get to that, I wanted to talk about this concept of kicking the can down the road, which is something that we see a lot. Have you guys you've heard that phrase, right? Happens a lot in negotiations, right? So you're in a negotiation and you're negotiating hard and we're not agreeing, right? And I can't get to you and you can't get to me, so we come up with some solution that neither of us really likes, right? And so we stick with that, and that solution may get us to a signature, but it may not be good enough down the road when you say, let's say you're gonna raise, $50 million from a venture capital fund, for them to look at that license and go, I'm comfortable with that license. That's what you really want. You want them to go, I feel good enough about that license to know that you have the rights that you need, so I'm willing to write a check for $50 million or whatever it is, right? So, kicking the can down the road, sometimes it's inevitable, like you can't stop it, but it does result in this situation down the road oftentimes where you're at an inflection point. Maybe you're selling the company, or maybe you're trying to get that big investment, right? And now you have to go back to the table in the middle of a super stressful, I can't tell you how stressful it is to be at that point where your company, you're like, if we get this $50 million, our company is gonna make it. If we don't, we're falling off the cliff in 2 months, right? And you're like, we got to get that, but now you've got to go back to the university or to those licensors and ask for some things, right? Sometimes that's helpful. Sometimes you can't get your licensor to move unless you're in that situation. And then you go back to them and say, look, you want us to be successful. You want the technology to get out there. And you because of my negotiation with you, I don't have a license that's going to get me this money. There's somebody ready with the pen in hand to sign it. It's time for you to back off of your position and give me a more commercially realistic, terms. So kicking the can down the road, just think about that as you're negotiating. And, it pays to be firm and tough sometimes in negotiations. Be rational, don't be irrational, don't be rude, but, to make a strong economic case that we want to be set up for success down the road and we need the terms that we need in order to make that happen. So the core of the license is what we call the license grant. That's where you're giving the license. I grant to you the right to do X, Y, Z, whatever. And usually it comes in terms of the patent statute, which talks about what are the rights under a patent. Making, using, selling, offering to sell, importing. Those are the rights that you get under a patent, right? Often that's a big part of the license grant. A grant you the right to make, use, sell, offer to sell, et cetera. There's this other category of having it made, and I'll talk a little bit about that in a second. There's also different types of license grants, right? There's exclusive and non-exclusive. Exclusive means I'm going to give you the rights exclusively. I'm not going to give them to anybody else, right? And you're going to be able to have exclusivity in the marketplace, which is going to give you a competitive advantage that nobody else is going to have because I gave that to you, right? Non-exclusive allows you, is like a license where I'm going to give it to you, but I'm also going to keep my options open to give it to other people. So you're going to have competitors. Usually non-exclusive licenses are just to get freedom to operate. Like you're going to infringe, you need this technique. Like a good example is the big thing in life sciences lately, gene editing, right? There's a bunch of patents, from MIT in gene editing, a bunch of patents from Berkeley, and they're like, hey, we're not going to give this to one company. This is too valuable. It's like it can be used in so many different ways, so we're going to give it to lots of different companies. So, but if you want to get into that gene editing space and edit genes using that technology, you need that license. So usually non-exclusive licenses are cheaper, they're simpler, but they allow you to use the IP, but they don't necessarily give you the competitive advantage that comes from having exclusivity.
Can you give an example of when you like to have an exclusive license?
Yeah, so let's say anywhere where you want to be the one company in the world that does it, but like a big one would be like a new drug for a cancer treatment, right? Like, it's really important in that space, right? If two companies are developing the same drug, one company could screw up with the FDA and screw it up for the other company, right? Because, so there's all kinds of things that could go wrong in that scenario. So you really want everything in one company so you could, make sure that everything's taken care of and it's done right. Another part of the license grant is usually the field of use. The whole thing about patents, like we talked about the bundle of sticks, a different analogy is a pie. You can slice up the pie any way you want to, right? So we sliced up the liquid logic pie, oftentimes by saying, here's our IP, and here's your IP, and here's the little intersection between the two. and we're gonna let you have that and nothing more, right? If you're out licensing, you wanna keep your field of use to what the other company's gonna actually do, right? If you make it bigger than that, you're giving away value that you're not gonna get anything back for, right? Because they're not gonna develop products outside that space. And you may have somebody else come along and say, I'd like that space, and you're like, oh, sorry, I already gave it to this company over here. That happened to us with the acquisition of Liquid Logic by Illumina. We had done that NuGen license, and Illumina was a DNA company. NuGen was doing sample preparation for DNA sequencing, and that was exactly the space that Illumina wanted. So as part of that whole Illumina acquisition, part of our stress was we had to unwind the whole NuGen license so that we had that to give to Illumina. So you can imagine how these things can get kind of complicated, and you want to make sure you're not giving up what you don't need to. Geographic territory is another big part of it. You know, if you've got a company, if you're out licensing to a company and all they do is make and sell stuff in North America, you don't want to give them Europe and Asia, right? Because you could give that to somebody else, and then that'd be another revenue stream for you. So like testing the company and saying, hey, well, are you really going to make it in these other jurisdictions? And maybe even requiring in the license, okay, well, you're going to sell this much in the Americas, you're going to sell this much in Asia, you're going to sell this much in Europe, you know, so that you have some requirements, and if they don't live up to it, you get the rights back, and you can give them to somebody else. And then another thing to consider is sub-licensing rights. Sorry, we are on the wrong tab. I'm on 12.
Which one? I can't see the number.
It's a license grant, right?
Okay.
Yeah, that's it. Okay. So, so sub-licensing, it can get kind of complicated too, because you can imagine, like, if you could sub-license to somebody and then they could sub-license to somebody else, and you know, it could just go and multiply, right? And you could wind up having, you know, like maybe you sub-license to a company because they're not your competitor, but then they sub-license to your competitor, right? So you could get all kinds of, you know, interesting competitive situations. So licenses often really will control sub-licensing rights, and so thinking through, you know, what are the rights you're going to get from sub-licensing, and how do you manage those? So now we're on that next slide. So understanding sub-licensing. So so sub-licensing is a way to take rights that you got from one entity and then give them to another entity, like we did at Liquid Logic, and it allows you to expand your markets. Like, we couldn't get into Luminex's bead space because they had the IP on the beads, right? But when we sub-licensed, we suddenly got ourselves into that space, right? So there are lots of ways to use your IP to get into spaces that you wouldn't ordinarily be able to get to and generate revenue. So some things to consider in sub-licensing, you know, scope and restrictions. You can only sub-license what you got, right? So you can't license, if you've got a particular field, you can't license outside that field, but you can slice that field up. Like, maybe it's diagnostics. I've seen, you know, a diagnostics field divided into pediatric diagnostics versus adult diagnostics, for example, right? Those kinds of things. You can keep slicing things up into smaller and smaller bits. Think about the approval requirements. One of the things that can be challenging in license agreements is when the licensor wants approval of your sub-licenses. And then suddenly you're trying to do a deal and you make some money and you have to go back to the licensor for approval. If they're a really nice university, like our university here, they're probably going to say, yeah, that's fine. But if they're like a company that wants to maximize, you know, their revenue, they might say, well, sure, as long as you give us X, Y, and Z, right? So they're going to extract a price for that approval. Anytime you need somebody else's approval on any agreement, it can turn into a real problem, right? So because at the moment when you really need it, they know that you really need it, and then they're oftentimes going to extract something. So, you know, when unwinding that NuGen deal that I mentioned cost a lot of money. Yeah, so you can imagine how that could happen. Sub-licensing can get complicated from a royalty perspective. Oftentimes, you know, so let's say you're going to pay the university 3%, and you're going to sub-license commonly, they'll pay you maybe 3%, let's say. And then you might have to split that 3% with the university. But sometimes the university might say, well, if you sub-license, I want them to pay me the 3%. So then you're in the situation where you've got to make more than 3%, or else you're gonna make nothing, because the university's gonna get it all. So you have to think through issues like that. Have-made rights are kind of cool. You often see this in license grants, and it allows you to allow another company to do something with the IP without it being an actual license. Because if it's a license, it's gonna perhaps trigger certain requirements in the agreement for sub-licensing, like reporting or payments or whatever. So have-made just means I can go out to a contract manufacturer, for example, and under the guise of my license, they're gonna make the thing for me. And that would be ordinarily an infringement of the patent, but in this case, because you give them these have-made rights, it won't be, and you can avoid some of the complications in the agreement because you have that. So I'm gonna move to development and commercialization obligations. So when you license, especially from a university, but even a company, they want to make sure that you're gonna actually do something with it, right? They don't want to give you their IP and then have you just sit on it, not do anything, not make any money. So there's various kinds of obligations. There are efforts-based obligations that focus on, things that you need to do. Like if it's a drug, you need to, do these kinds of studies first to get it ready for the FDA. You need to file a certain kind of FDA application by a certain date. You need to have approval by a certain date. You need to be selling a certain amount by a certain date. So these milestones, so that's like to put some incentive on you to make sure that you're doing the things you need to get this thing to the market and fully take advantage of it, right? You want those to be like usually clear and measurable targets. Problem comes in when they're not clear and measurable. So like I've seen a lot of times, like a license that says, you have to do a certain research project and we have to approve of the results of the research project. So that goes back to that approval thing. Like, how do I know what's gonna cause you to approve it? You might not approve it because you just don't like us that day, or because you have a better buyer for this technology somewhere else and you want to get out of this, right? So you want to put really strict, specific obligations, right? It's a project that had this many subjects, that had this result, if it's a drug, it showed this, measurable result, those kinds of things to make sure that there's no ambiguity, no subjectivity in determining whether the milestones are met. And then most licenses have a hybrid approach. They have some kind of efforts-based obligations as well as some efforts-based obligations. Efforts-based obligations are like, they could say best efforts. You have to use your best efforts to develop this, or you have to use commercially reasonable efforts. Those are all like legal terms with a lot of reasoning behind them that result in different things. And so like best efforts, really requires you to go all the way and do, to try to develop the product. So it may not allow you to make reasonable business decisions, It's like you've got to use your business resources, your resources to develop this thing, or else you're going to breach this license and then you're going to lose it, right? Whereas commercially reasonable efforts allows you to be able to make some business judgment. You might say, well, right now it's commercially reasonable for us to pursue most of our resources towards this other thing over here, and a little bit of our resources towards developing this licensed technology, right? And then, there are all kinds of things that come into play, like in making those decisions, market, considerations, regulatory considerations, all kinds of things that may come into play, and you're allowed to weigh all those things out and make reasonable decisions. I'm going to skip this slide. This sort of repeats a little bit of what I've already talked about, but it'll be in the deck if you guys want to look at it. So why is use of milestones? So thinking about milestones as, the requirements for you to keep your license, right? Some one thing is to define clear objective milestones, which I talked about. So you want them to be measurable events, you know, regulatory approval, product launch, things that everybody knows when it happens. You want to avoid licensor control of success, such as things like successful trial or approval by licensor. And consider unintended consequences of the incentives that the milestones create. So, like, for example, we had a milestone when I was at Illumina. We had done an acquisition and put in a milestone for a patent grant. And then suddenly, you know, they were going to get paid money when the patent granted. And we were in charge of actually doing all the prosecution and everything. So we had one set of objectives, which was to cover our product and have a good, strong patent. They had a different set, which was get anything allowed and granted so we could get paid. And it just so happened that their payment was in Illumina stock, which is going up a ton. So what was maybe like a $5 million milestone was like a $50 million milestone. Like, it was a massive difference, right? And so we had the sellers calling us every day. How are you doing on the prosecution of that patent application? I don't really like the strategy you're proposing here because it might take longer to you know, grant and et cetera, et cetera. So think about those kinds of things. It get kind of complicated with how those milestones set up unintended incentives. It's important to balance, you know, accountability with flexibility. So you want to have, you know, first of all, realistic development timelines. You know, really think hard about how long it's going to take to do things and build in that buffer because everything always takes longer than you think it's going to take. And then build in ways to delay things, like very oftentimes, you know, licenses have terms that allow for extensions for legitimate delays in meeting those milestones. You want to stagger the milestones out. You don't want them piled all on top of each other, so you're trying to meet a bunch of milestones at the same time. Those are just a few ways to kind of wisely use milestones. The other thing that's important is to specify, like, well, okay, what happens if I miss a milestone, right? You could just have contract termination. Why would that be bad?
Well, you're basically dead in the water at that point.
Yeah, that's right. So you've basically poured a bunch of money into developing a product, and now you have no license. You have an infringing product, right? So you want to have flexibility in there. Some ways to do that, maybe you have financial penalties, or maybe you have sort of as a worst case scenario, you've reached the milestone, you've got a cure period, say 6 months, and if you don't cure it within 6 months, then they can terminate. If they do terminate, a lot of times licenses will, instead of just terminating altogether, they'll go from exclusive to non-exclusive. So then you still have the rights, the licensor gets the rights back to license to others, so you don't have that exclusivity that you had, but you don't get stopped, you still have a product. Hopefully, over the development of that product, you've developed your own IP, so you know, you've got IP to protect yourself, and so you're good to go. Okay, so another interesting thing that comes up in patents is this possibility of paying sort of royalties forever and ever, right? So you don't want to, you know, usually royalties are tied to the term of the patent, but in certain circumstances, they can just keep going on forever. So this is like an example. So these are like from actual terms. So let's say royalties are payable on licensed products covered by valid claims of the licensed patent. Okay, so that makes sense. So if you've got a valid claim, you got to pay a royalty. But the term valid claim is defined as a claim of an issued and unexpired patent or a pending patent application. Okay, that's interesting. Can anybody see why that's a problem? So instead of having a granted patent that you can enforce, go ahead.
If your patent takes extra time to clear, then you're something like 20 plus.
Yeah. So it could take a long time for a patent to grant, and while it's pending, you can't enforce it, so you don't really have that exclusivity that you're paying for, right? But you're paying the royalties, and And a patent could never grant, like, patent application could go on pending for 20 years, right? The licensor could just keep it pending for no other reason than to make sure that you're paying your royalties, and you could never get a patent and never really have any serious value out of the whole thing. So so that's the problem, right? You could be required to pay royalties forever with no real benefit, or at least for a long time. So one solution is to say, okay, well, we're gonna change the valid claim definition to be, instead of just, a pending patent application, we're gonna put a limit on it. So let's say a patent application that's been pending for 5 years from the time we filed it. So if at 5 years you haven't gotten a patent, then we don't have to pay royalties anymore. That seems pretty helpful, right? What's the problem with that solution? Anybody see it? Sounds like a pretty good solution, right? So the problem there is, like, you can keep filing divisionals and continuations off of that patent. So you could get to 5 years and then you say, okay, I'm gonna file a divisional or continuation application, which is just another application of the same family, start the date from 0 again, and wait for 5 years on that one, right? And at the end of that, so that's a helpful solution, but it's not, a full solution. So a better solution is to have, a date that is tied to the priority date of the patent application family. So the priority date of the family is like the very first patent filed in the whole family. And it can branch out, and you can file, applications and continuations, and, it could turn into a big tree, and you've got international patent applications, right? But they all have the same priority date. So if you limit it to, a certain number of years from that priority date, then you can solve for this problem. So here's another one that's definite royalties on trade secrets and know-how. So you've got royalties payable, covered by valid claims, et cetera, or based on license and know-how, right? So now you've got the patents, which are gonna expire in 20 years, but trade secrets and know-how can go on forever, right? As long as they're kept a secret. So you could find yourself, if you're paying under the trade secrets, that you could be paying forever when you really shouldn't have to. So even after the patents expire, or the information kind of becomes obsolete. So some potential solutions for that, no royalties on the know-how. Another is royalties terminate with the patents. You could require that, okay, the royalties terminate with the patents regardless of whether I'm still using the know-how. So there are a number of fixes for that as well, to keep you from. These are just illustrations. I want to illustrate, like, little nitpicky legal things that your lawyers love to work on that probably would drive you crazy. There are tons of these in license agreements. We often have clients that just take whatever the license agreement is that the university offers and sign it. And they don't look at all these things. And then they're in that situation down the road where they're having to go back and renegotiate. So, how are we doing on time? So, I've got a couple more slides, but I think I'm going to skip these slides. They're about termination, and just throw it open and see if you guys have any thoughts, questions, anything for discussion.
Question I have is, how do you go about trying to discover what licenses are in place, other than looking at who they're assigned to?
Yeah, that's a good question. It can be hard to do because they're not necessarily public.
Yeah.
Right. In Europe, they do register licenses, so if there's a license in Europe, you can find it, by looking it up. In the US, we often just do like an anonymous call, so we'll have somebody from the law firm call up a university or company and say, hey, I've got somebody who's interested, because we don't want to flag them to, like, it's this person who's interested, because then they start watching, right? Mm-hmm. And then maybe you wind up getting a lawsuit. So, yeah, usually anonymous contacts.
A question about the know-how of this. Let's say that the equipment that you've come up with already has previous patents that have expired and things are more or less passed into the public domain, but you've got a new way of using it. Mm-hmm. How does one go about protecting that and and doing it in a way that you can then use it, or license it or whatever. I mean, it simply becomes a lot less tangible and a lot more thorny, so delve into that.
Yeah, so you wanna keep, know-how in that sense as trade secrets, so and in order to keep to have rights in a trade secret, it just requires you to take the steps needed to keep it secret. Because the way trade secrets work is like, let's say you've got a trade secret, I steal it from you, right, and I use it, and then you sue me for infringement of your trade secret, right? Then the court's gonna come, like, look at the situation, and they're gonna say, okay, first question is, was it really a trade secret? And they're gonna come back to you and say, how did you protect it? And if you had like an office that was open and people could just walk in and out, and you had, you know, a server that had everything on it and everybody in the company had access to it, or if you commonly had discussions with other companies where you explained it, but you didn't have a confidential disclosure agreement in place, all those things the court would say, yeah, you didn't really protect it as a trade secret, it's not a trade secret, you got nothing. But if you come back and say, hey, we got a trade secret policy, we trained our employees on it, everybody knows they're supposed to protect it, we've got a list of trade secrets that are our most important trade secrets, we educate people on what those are, we keep them in a specialized laboratory room that's got a lock on it, not everybody can get in there, and all those kinds of things. Then the court will say, okay, that was a trade secret, you can enforce that. So the same thing, so you've got that trade secret, you go to a company, you wanna license it, they're gonna ask you the same questions. Did you protect it as a trade secret? If you did, then maybe it's a valuable trade secret that's worth licensing. Usually trade secrets are really only the things that can keep a secret well. Most things you can't keep a secret that well, right? Employees go from one place to another, people independently come up with the same ideas, all those kinds of things. But the kinds of things that are good trade secrets are deep in the heart of your company. It's like you've got a clean room and you've got a set of equipment in there, and you turn this dial to 6, but you put it a little bit over 6, like all those little things, all those little tweaks that you have to come up with when you're coming up with a manufacturing process, for example, right? They make good trade secrets.
So an example of a bad trade secret is something that you have to basically install for the customer, and it's sort of sitting there and they can look at it anytime.
Yeah.
That's
Exactly,
not really.
yeah.
Okay.
Out in the open, yeah, exactly. Yeah.
We're talking earlier how licensors usually have the upper hand because they have something that they want. But what about situations where there's like teeny tiny companies licensing to big companies? Do you have any tips to help the teeny tiny companies not end up with a bad deal?
Yeah, well, one thing is, and I don't mean to toot my own horn, but, is get good counsel, because, like, people that are in, and I'm a patent attorney, I don't do this every day for a living, but we have people at my firm that do. And so they're in those trenches all the time, they know the tricks, they know what's standard, they know what's laughable, when somebody requires it. And so they can really help with that negotiation to make sure that you're getting commercially reasonable terms. But also just having a good backbone, like it's scary, to go in and you're like, okay, I've built this company, I've thrown my life into it for several years, and now everything's riding on this transaction. You really want to put some ink on that paper and get that thing done, right? You have to be able to be cool enough to say no and let it sit for a little while sometimes and wonder if they're going to come back, and do those kinds of things in order to make sure that, you're putting enough pressure on them to make sure that you're getting the terms that you need to get.
Would it be helpful in that situation if she had more than one big customer that would be interested in what they have?
Absolutely,
Have the
yeah.
bargaining power?
That's right, yeah. Yeah, definitely helps to have competition. Yeah, exactly.
How can the firm that represents both sides?
We can't, so,
okay.
yeah, and that's a good question. So I literally came up just yesterday. One of our clients asked us if, we're like, oh, we're friendly with this other company, you could represent both of us on this license agreement. And we're like, no, can't do that. There are some conflicts of interest, that are waivable, and that both sides can sign a waiver. but being on the opposite side of a transaction like that is not favorable.
I just wanted to endorse your comment about bad agreements. I've done a fair amount of litigation support as a CPA, and I've made the most money off bad agreements. And had they done the agreement well at the beginning, they wouldn't have been paying so much on the back end. So
Yeah.
if you do it on the front end, you're always better off.
That's true, yeah. And sometimes I think there's almost like a correlation between intelligence and bad agreements. Like, the smarter the founders are, the worse agreements they come up with. So we have spin outs from like MIT and Stanford, and they, you know, I think it's because they kind of think they know, you know, like, and they don't, and then, yeah.
They think they know what they know, they're usually smart.
Absolutely.
I'm curious, can you talk a little bit about the complexity or affordability of licensing for trade secret or patents for the country?
Oh, yeah, totally. I mean, obviously, different countries are different, but it's very common to do, you know, transactions, licensing transactions, country to country. And it can be really helpful, like I was saying earlier, where you might have a U.S. company that you work for who's really great at making and selling stuff in the U.S., but then you want to go to a European company to make sure that you're getting the most out of Europe, that kind of thing. Obviously, the countries like China can be a little more challenging, you know, in terms of enforcement and those kinds of things, but even there are ways to do it that kind of maximizes your chances of success.
So enforcement is
Yeah, I mean, it's better in some places, worse in other places. But, like, for example, in the places where you normally think of it as not being so good, like China, you can kind of set up a situation where you're basically enabling a Chinese company to make and sell your product in China, as opposed to you making and selling your product in China. And then if there's a patent infringement lawsuit, if a Chinese company is suing a Chinese company, which is more acceptable in China, you're more likely to get a fair result out of that than you would if you were to go over and try to sue a Chinese company. Yeah.
You only talked about, how both sides, in approaching a licensing deal, how both sides kind of protect themselves. I'm thinking, you know, in the case of a company approaching an inventor, a small IP holder, they're coming in and saying, hey, I see this market, I see this path to revenue. How can that company protect itself from not creating a competitor by disclosing the market and the use of that technology? And on the flip side, if you're the inventor or the IP holder, you have to sign an NDA with 5 different possible suitors. Are you limiting your approach to the market going forward? Can you sign NDAs with all these people with these great ideas on how your technology can?
Yeah, that's a really complicated question. That's a great question. Because if you're out there gathering information under NDAs and you're educating yourself based on those, right? But you're using information that you can't use because it's confidential, they're confidential information, that's problematic. So you want to kind of limit, we call that contaminating your company with their confidential information, right? And if you're small, like if you're a bigger company, you're gonna be like, okay, well, I'm gonna have this one little group over here is gonna do all that vetting of these companies, and my R&D guys over here, I'm not gonna give them any of that information. So if they come up with it independently, that's great, you know. So, but contamination is definitely an issue. I think probably the main way to deal with it is to be really like let the other side know what you want to talk about under a CDA, and make sure you keep it focused on, you know, what you have to talk about in order to achieve the business purpose discussion.
You know, one of the things we try to think about all the applications. Write them down. We thought about this.
Yeah, we do that a lot. So it's very common for our clients to come to us and say, oh, let's say they have kind of a platform and it can be applied to a bunch of different areas, right? And they're like, next week we're gonna go talk to this company that could use our platform for X. So we sat down and brainstormed all the ways that our platform could be used for X, and we'd like to file a patent application on it Friday, and we're gonna talk to them on Monday, right? So you've got some protection for what was already in your company, because that contamination thing, you know, you could kind of be contaminated even if you already had the idea, but you didn't document it. Because it's gonna look like you stole it, and that happens a lot. When we sold, our company Liquid Logic to Illumina, we did that with Illumina, so we were gonna use our technology for sample preparation for DNA sequencing, so we filed a patent application. And then after the transaction, I went to work for Illumina, and I found out they did the same thing. So we had two patent applications, one from our perspective, applying our technology to their technology, one from their perspective, applying their technology to our technology, and, you know, filed within days of each other, yeah. Can't remember who won that, but, yeah. So it's definitely, and you wanna think about that too, right? Like, if you don't do it, they might be doing it, right? So, you know, if it's a really important space, a really important technology for you, you think about filing something. I think that's all the time, but, I'll hang out if anybody wants to talk afterwards, but thank you guys very much.